Let's begin the broadcast with some breaking news coming in. The Supreme Court has granted interim bail to Teesta Setalvad, who, remember, was arrested by Gujarat police for allegedly conspiring to destabilize the state government during the 2002 Gujarat riots. Now, Teesta Setalvad has, in fact, she has been given bail after being in custody for over 60 days. The Supreme Court going on to say that the appellant in custody has been in the custody for more than 2 months, and that she is entitled to relief in the form of interim bail. Meenakshi joins us live on the broadcast for more on this. Meenakshi, this does seem like, some balance has been restored by the top court, because there's been a lot of talk about how, bail should be the norm and not jail. And also yesterday we saw how the High Court had to face some very tough questions. What happened in court today that led to the Supreme Court giving Teesta bail?
Well, that's right. You see, in criminal jurisprudence across the world, including democracies like India, which are governed by the rule of law, the doctrine of criminal jurisprudence is that bail is the norm and jail is exception. This doctrine is followed vehemently in India as well, because India is a country which is governed by the rule of law. That is something that has weighed predominantly in the Honorable Chief Justice of India-led bench, as it has gone ahead and granted interim bail to Teesta Setalvad. Let's quickly take our viewers through what has transpired thus far. Since yesterday, we have seen the solicitor making representation for the Gujarat government argue before the Supreme Court that because Teesta's matter is coming up for hearing before the High Court on the 19th of September, therefore the Supreme Court should not entertain this petition at this point in time. It will set a very bad precedent. However, what has weighed predominantly in the Supreme Court's mind today, and I am quoting from the orders which were pronounced by Honorable Chief Justice of India-led bench in the Supreme Court, is this, and I quote, "The essential ingredients of investigation, including custodial interrogation, having been completed, the matter assumes a complexion where the relief of interim bail till the matter was considered by the High Court is evidently made out," unquote. So the principal factor which has today brought about this order from the Supreme Court is the fact that, one, she is a lady, 60 years of age or so. She is someone who has spent over 60 plus days in custody. She's someone who's been subjected to custodial interrogation, which today the solicitor said that she has not cooperated in. But be that as it may, custodial interrogation of Teesta Setalvad has not yielded any fresh material which could have satisfied the Supreme Court, and that apart, till the regular bail matter is pending before the High Court, it is a case, according to the Supreme Court, which is fit for granting interim bail to Teesta Setalvad. That is why the Supreme Court has gone ahead and granted this bail, considering that all the provisions under which she has been booked are normal provisions of the Indian Penal Code. No special law like the UAPA was invoked in her case, and therefore this is a fit case for the Supreme Court to intervene at this juncture. But big relief coming for Teesta Setalvad, and a hotly contested matter. Since yesterday, we have seen a volley of sharp questions being raised by the Supreme Court, directed at the solicitor, because he was making representation for the Gujarat government, Gujarat police in this case. The Supreme Court wanting to know as to why shouldn't a lady or any lady be granted a favorable view or favorable hearing, given the fact that the doctrines of criminal jurisprudence in India are very well established. One of the doctrines, like we just reiterated, and we heard a lot of expert panelists also on Mirror Now reiterate the same, that bail is the norm and jail is an exception. The second most important part, no fresh additional material was furnished by the investigating agency in this case. And thirdly, yesterday's sharp questions that the Supreme Court posed about the practice in Gujarat, where a matter has been admitted, notice has been issued, and a long adjournment date has been given if that was a practice followed in the Gujarat High Court or not. That question today the solicitor tried to satisfy the court on. He gave several examples, but be that as it may, the Supreme Court's opinion has hinged on three primary aspects: investigations into the case completed, custodial interrogation of Teesta Setalvad, not throwing up anything additional or new material which justifies her continued incarceration. Three, the provisions that she's been booked under are the normal provisions of IPC. They do not attract a special statute like the UAPA, and therefore bail is made out for the interim period till the High Court considers her regular bail plea on merits. That apart, the Supreme Court has also ordered for her to submit or deposit her passport before the trial court, because as we know, all bails are conditional, and this bail, interim bail from the Supreme Court, is also conditional, which is why the Supreme Court has directed Teesta to surrender her passport in the trial court, and has also made it clear that the High Court will decide her regular bail plea without being influenced by the present or today's orders of the Supreme Court. But relief coming in for Teesta Setalvad, because this is exactly what the Gujarat state was opposing before the Supreme Court, wanting for the Supreme Court to keep its hands off the issue, but the Supreme Court clearly not convinced, going ahead and granting interim bail to Teesta Setalvad.
All right, Meenakshi, thank you so much for getting us all those details. In fact, we're also being joined by Karuna Nandi on the phone line. Ma'am, thank you so much for speaking to us here on Mirror Now. I want to start off with understanding the fact that now Supreme Court, after 2 long months, in fact more than 2 months, has given bail to Teesta Setalvad, and also coming down, very heavily on the court, saying that you have taken unusually long in order to consider the bail plea, and also going on to say that there's absolutely no reason why, she should be in jail. How do you see this entire, the fact that the Supreme Court has given her bail today?
I think it's extremely welcome, and it's a rectification of what was a real travesty of justice. What the Supreme Court had observed on previous occasions was that why are such long dates being given, for example? Why are periods of 6 weeks, why are adjournments of 6 weeks being given by the High Court? One. And secondly, that when a woman is in jail for such serious, with such serious accusations, I mean, surely there should be an examination of the bail application. I think this was the fact that once the current Chief Justice, Justice Lalit, had taken up the matter and swiftly acted on the issue, the fact is also that there is an undoing of an injustice that had been happened in the previous judgment of the Supreme Court that concerned Teesta Setalvad, which spoke of without notice to her, which spoke of her, in terms that were very problematic, procedurally speaking, quite apart from the substance of the findings, which is what the police was, which is what the state was relying on when they arrested her, right? So it's a good day, and it's a rectification of the problems that have currently existed. But I think we must remember that nobody can return days of lost liberty in prison. And I really hope that when there is a final adjudication on the decision, that damages are granted. And I think consistently, when there is an overstepping by the state in such a serious way in this regard, then apologies and damages should be consistently ordered by the courts, because it's happening too frequently these days.
Ma'am, also, do you think it will be safe to say that, some sort of a balance has been restored, given that these days, not giving bail is seen as a way of punishing an under trial?
It is a way of punishing an under trial before there is any conviction, right? And I think that the basic principles of bail, that is there any case against the person, or is there an adequate case made out, even in the allegation? The fact that will there be interference with the course of the investigation? Will there, the sort of basic principles of bail, and looking at the main Supreme Court judgments and the jurisprudence that has come down the ages, which is that the default is bail, not jail, and sort of starting from that premise, I think is incredibly important. And particularly when we see speech provisions that have come down to us from colonial governments, when we see UAPA provisions being used with a degree of impunity that is disturbing, I think particularly in those cases, a close examination by courts and prompt grant of bail is vital.
Right. Karunanandi, thank you so much for joining us and speaking to us here on Mirana. Always a pleasure. In fact, I'm also being joined by Geeta Luthra. Ma'am, thank you so much for joining us and taking out time. Let's take a step back and look at what the court has said while granting bail. It says that the hearing, the High Court hearing has taken unusually long period of 6 weeks. The custodial investigation has been done. The essential ingredients of investigation has been taken care of. So absolutely no reason why Teesta Setalvad should be in jail for so long. What do you make of these observations by the court?
I think they're very welcome. There used to be a time when we would be practicing, and when somebody was in custody, the courts would put it, after 2 days or 3 days. And I now see some youngsters coming out of court and say, "Ma'am, we got a date after 1 month. Our accused is in jail." And you come back and you tell them, the high courts and senior courts have started giving notices after a month and a half, maybe because their docket is so heavy. But we have to do something about this docket. When somebody is in custody, there are courts, and even now the courts say repeatedly, even 1 minute of wrongful incarceration is a 1 minute too many. So with the jurisprudence on bail, I think it's very welcome, because I know it's a heavy load on the court. We can't say that the High Court doesn't have heavy loads, but ultimately, liberty of an individual is involved. We have to have earlier hearings, particularly where almost there is not much to investigation. It's really the Supreme Court judgment which has been repeated in the FIR. So in such cases, in fact in all cases, whether bail has to be ultimately rejected or accepted, unless there are cases, of the nature where very in-depth investigation is required, there's apprehension of tampering, the investigative agency says the repercussions are manifold. Unless those kind of cases are there, bails have to be heard. Notices have to be taken up expeditiously, whatever the state may say. Because once the court pushes the state to give a response, the state has no option but to reply. If it means 24 hours, they will reply in 24 hours. If the court gives them 48 hours, they'll reply in 48 hours. So what we need is that bails after notice, where persons are in custody, should be heard extremely expeditiously. And I'm mindful that the courts do have a heavy docket, but ultimately we're talking of the liberty of the individual.
Right.
And although the courts try, the fact is this observation by the Supreme Court is very welcome.
Ma'am, you've been practicing at the Supreme Court for like very, very long years. You've seen a variety of cases. And as you say that the docket is long. But what can we do about this long docket? Because at the end of the day, people are rotting in jail for like years together. I mean, let's not talk about whether they deserve it, they don't deserve it, whether they're being investigated for it. That's the other part of the story. But the fact also remains that they have, they're languishing in jails for like years, and even some for decades together.
So what can you do about it? One can just give. So, every time I look at a matter in depth, say any matters which may be cheating and therefore the livelihood of a person may be involved, one or the other party, or criminal matters or civil matters where even a tender where a person may be wiped out from life. I keep saying these matters have to be dealt with urgently. But having said the whole depth of all kind of practice, bails cannot wait. I feel every case requires expeditious hearing. I believe every case may require fast-track courts. And then the courts would not be fast-track courts. They'd be normal-track courts because all courts would be fast-track. But the fact is, bails are something which have to be treated as extremely, extremely urgent, which cannot brook any delay. And there can't be exceptions to that. There can't be exceptions to human liberty and to the aspect that what Supreme Court, even very recently, which was much celebrated judgment in Satinder and Till. So all these aspects make, and court after court has said it, let's be sensitive to this aspect. Where is human liberty going to be if you're going to let a bail petition be decided after 1 or 2 months?
Absolutely. Some very important...
There's no exception.
Absolutely. Some very important points coming there. The most one, that the bails can't wait, no exception to human liberty. Ma'am, thank you so much for talking to us here on Mirror Now.